He saw 3 clues. The court observed him complete the HGN. Did not look like any HGN this court has ever seen performed in the hundreds of trials that the court has observed. Everything will be suppressed as fruit of the poisonous tree. The people may call their first witness.
Your Honor, at this time, the people call Officer Wood to the stand.
All right.
Carson Wood, W-O-O-D.
And where do you work?
At the Littleton Police Department.
What would be your title at LPD?
Patrol officer. I conducted a routine traffic stop on a vehicle that was not displaying rear license plate. We had made a eastbound turn onto West Mineral Avenue from southbound on South Santa Fe Drive. The vehicle slowed immediately, made a left veer with a delayed turn signal, acting as if it was going to make a northbound turn onto Jackass Hill Road. Then the vehicle cut across all lanes of West Mineral Avenue and made a southbound turn onto West Long Drive, I believe is the
Camera.
Yes, sir.
Looking at that temporary plate, what is the expiration date on it?
September 4th of 2024.
And when was this traffic stop?
June 17th, 2025.
Were you able to have a conversation with this individual?
Yes, sir.
Was there any observations made prior to having to open the door being opened to the vehicle?
Yes, sir. The odor of marijuana and a plain view observation of pipe with residue inside of it. I believe it was a glass pipe that had a charred green substance in it.
At what point did you ask if that driver would be willing to perform standard field sobriety tests?
I believe that would have been after the conversation about the objects found inside the vehicle.
What information had you already gathered that led to you asking if he wanted to do standard field sobriety tests?
The suspicion of impairment.
And what was that suspicion based upon?
The driving behavior and the plain view observation of multiple indications that marijuana had been recently consumed.
Do you recall how you asked that driver to do standard field sobriety tests?
Yes, sir. I believe I asked him if he would be willing to exit the vehicle.
And do you recall what his response was?
Yes.
As it relates to your investigation, did you call a drug recognition expert?
We did not have any qualified drug recognition experts on staff.
Your policy with Littleton Police Department as of June of last year, is there a requirement for a DRE to be called when there is suspicion of impairment by driving for marijuana or other drugs?
No, sir.
Which tests did you conduct?
The horizontal gaze nystagmus test with the vertical gaze nystagmus, the walk and turn, and one leg stand.
Based on these tests being conducted, what did you do next in your investigation?
Would have to refresh my memory if a PBT was conducted, but alcohol was not suspected, so I would not be surprised if that portion of the test was omitted. However, at the conclusion of those tests, the probable cause determination was made.
During this initial conversation with the driver, while he's still in the driver's seat, was there admissions to consuming marijuana that day?
Yes, sir.
Was it before or after that individual was arrested that Colorado Express consent was raised?
After.
Could you kind of walk me through how you asked or walked through the Colorado Express consent advisement?
Yes, sir. Due to the suspicion of drug usage and that not being able to be discovered through a breath test, only a blood test was offered.
Did he elect to take a blood test or refuse to take a chemical test?
I don't remember, sir.
Would looking at your report refresh your recollection?
Yes, sir. Yes, sir. It looks like he consented to the blood draw.
Your Honor, I have no further questions.
Anything did you do to prepare for today's hearing?
I've reviewed my report and the information that the prosecutor's office has given me.
What did that information include?
This exhibit and this disc.
Did you review your body camera video?
No, sir, just the body cam from the disc.
Was that approximately a 4-minute clip?
Yes, sir. That only went from the time that the suspect exited the vehicle to the end of the first test, the horizontal gaze nystagmus.
How long have you been working in law enforcement?
Almost 2 years.
And do you have any specialized training in DUI enforcement?
No, sir.
Are you aware that there's a program called drug recognition evaluation?
Yes, sir.
Do you have any training in that type of program?
No, sir.
Do you know what A-RIDE certified means?
Yes, sir.
What is that?
It's an additional set of tests that you can perform after the standard SFSTs.
And prior to June 17th, 2025, had you taken any A-RIDE training?
No, sir.
So an officer must be certified in A-Ride to be able to do those maneuvers. Is that fair to say?
Yes, sir.
And that's why you didn't conduct those maneuvers on Mr. Vargas, right?
Yes, sir.
Those maneuvers are tailored specifically to detecting drugs as opposed to detecting alcohol, right?
I'm not sure, sir. I'm not certified in A-Ride.
Did you take the standardized field sobriety testing course during police academy?
Yes, sir.
As part of that training, did you have to review the NHTSA manual?
Yes, sir.
And you had to review that manual to pass the class. Is that fair to say?
Yes, sir.
So as a result of your training, you're very familiar with the NHTSA manual. Is that fair to say?
Yes, sir.
What does the manual say about the percentage of accuracy that the HGN has for detecting marijuana impairment?
The HGN test is not typically used for detecting marijuana impairment.
What does the manual say about the percentage of accuracy that the walk and turn test has for detecting marijuana impairment?
I'd have to review the manual, sir.
Now, as of June 17, 2025, approximately how many DUI investigations had you conducted?
I do have a Excel spreadsheet that tracks that. I do not have that information in front of me, sir.
Do you have an approximate amount?
Under 10.
And then during your police training, did you take any courses on how to write a police report?
Yes, sir.
Did those courses instruct you to include all the important details that are relevant to the reason for the arrest?
Yes, sir.
And after you completed your investigation of Mr. Vargas, you authored a written report, right?
Authored? Yes, sir.
How long did Mr. Vargas or the blue Ford Fusion drive going on Mineral before you turned on your overheads?
I don't recall, sir. Typically speaking, my lights are activated after the light is turned green in the middle of the intersection.
Approximately how long do you think, while your overheads were going, how long did he drive before he tried to, as you described, go to the left first and then back to the right?
I don't recall, sir. Seconds.
Did he slow down upon seeing your lights?
Yes, sir.
And then after turning onto Long Avenue, he came to a stop.
Yes, sir.
Did he hit the curb?
I don't believe so, no, sir.
Did the car lurch from hitting the brakes too fast or anything else unusual like that as it stopped?
I believe the stop was normal.
You testified that you smelled the odor of marijuana upon contacting him, right?
Yes, sir.
But not the odor of burnt marijuana?
No, sir.
And he acknowledged having smoked at about 5 p.m.?
Yes, sir.
And at the time you contacted him, it was just almost 10 o'clock p.m., right?
Yes, sir.
Do you recall him telling you that he has a baby at home, so he goes outside to smoke marijuana in the car so it doesn't affect the baby?
That sounds right.
Did you observe his pupils to be dilated or constricted?
I don't believe that's documented in the report, sir.
And then just to be clear, was there anything you observed to believe that he had been consuming alcohol?
No, sir.
And you asked Mr. Vargas if he was willing to perform some roadside maneuvers. Do you believe you advised him that they were voluntary?
Yes, sir.
Do you believe you advised him that he could refuse?
Based on the language of the question, yes, sir.
You mentioned that you did have to go where the stop occurred was a little bit of a hill. Is that right?
Yes, sir.
So how far did you walk to get to the location where you did the roadsides?
I'd say it's probably 25 yards or so.
And you didn't observe any unsteadiness as he walked?
Down the hill, is that the question?
Correct.
No, I don't believe that's documented.
And his gait was normal?
I believe I acknowledged that his movements were slow.
But you didn't notice any other issues with his balance?
Not during the walk to the downgrade section.
Questions, right?
Yes, sir.
And he said he had astigmatism?
Yes, sir.
And also that he was having back spasms and back pain?
Yes, sir.
Are you aware that astigmatism can cause nystagmus?
Yes, sir. Not necessarily nystagmus, but it can interfere with tracking of the eyes. Yes, sir.
Do you score the tests any differently if somebody's complaining of back pain?
No, sir.
How many clues did you observe on the HGN?
3.
Is it unusual to observe an odd number of clues on HGN?
Yes.
What does the odd number indicate to you based on your training?
Either some sort of other interference from the eyes, the natural or unnatural effects of the eyes, or just a ability to observe the other clue.
When you watched your body camera today, did you watch the portion where you did the roadsides?
Just the HGN, sir.
Did you observe yourself make any mistakes during the HGN?
I do believe that in my report I indicate 4 seconds were held on the maximum deviation, but I did not count 1001, 1002 out loud like I typically would do. Other than that, no, sir.
I have no further questions. Thank you.
I offer standard field sobriety tests.
That's typical protocol if we believe some sort of impairment.
Because the NHTSA rate says that this test has an effective rate for a BAC over 0.08, does that mean it doesn't have any effective rate for identifying any impairment, even if there's no ethanol involved?
I believe it could indicate other impairment other than alcohol.
Are you aware that drug recognition experts conduct an HGN evaluation during a drug recognition exam?
Yes, sir.
No further questions.
Further witnesses from
As
the
the
people?
suppression hearing unfolds, the defense challenges the officer's training, experience, and observations. Questions arise about the validity of the field sobriety tests and whether proper procedures were followed. With key evidence under scrutiny, the case begins to shift toward a pivotal legal battle over probable
Further
cause.
witnesses from the people?
None of the people have no further witnesses.
All right. From the defense?
No witnesses or evidence, Your Honor.
Okay. Mr. Slifka, I did review the 4-minute video before the hearing. Could you play it for me again, please?
I'm playing People's 2-MO.
Thank you.
So here's what I'm going to ask you to do. I'm going to ask you if you're willing to perform some roadside maneuvers.
Yes, sir.
Okay, great. So please step out of the vehicle. And I'm just going to go all the way down where it's nice and level and flat. Okay. So all the way down to like this light right here. I just don't want you to be thrown off guard by the slope of the hill at all. Okay. Okay. So probably right around here is good.
Okay.
All right. So we will go ahead and face this direction. I'll come over here. And any lights bothering you right now?
No.
Okay, great. Do you feel like you're obstructed by any sort of medical procedure that you've had recently?
No, I mean, I got a back spasms. That's
Yeah.
what those are
Yeah, you
for.
mentioned that.
Yeah, but that's about it. That's
Okay.
it.
Back spasms. Do you wear contact lenses or glasses? Okay. Have you had any head injuries recently?
No,
Okay. Are you under the care of a doctor for any reason right now?
no,
Okay. And then how many of these did you take?
no,
What did you take?
no. I only take one each night.
Okay. When's the last time you took one of these?
Last around 8 p.m. last.
Okay. Are you
Not tonight, yesterday.
on any other prescription medication?
No.
Okay, got it. So the first test is going to involve your eyes.
Okay.
All right. Do you have any resting nystagmus? You know what that means?
No,
Okay, great. Any other problems with your eyes?
no.
Okay. Do you wear corrective lenses?
No, I'm supposed to wear glasses. I got astigmatism, but I just don't.
Okay. But do you have any problems seeing objects?
No.
Okay, close objects, far objects, you're good.
No. Yes, sir.
Driving without lights.
Yes, sir.
Okay, great. So I'm gonna have you put your feet together, heels together like this, arms down to your side.
Want me to face you or face?
It's exactly where you are right now.
Right.
All right. Remain in this position until I tell you otherwise. Go ahead and put your toes all the way together. Okay. Do you feel like you're wearing comfortable shoes right now?
Yes, sir.
Okay. And this is a flat level ground.
Yes, sir.
Okay, great. So for the first test, I'm going to have you follow my finger with your eyes and your eyes only. Okay. So go ahead and look straight at my finger.
Okay.
All right. So again, with your eyes and your eyes only.
Okay.
Okay. I'm going to go vertical. Keep following with your eyes.
Okay.
Okay. Go ahead and relax. So for this next test,
Out of my.
yeah, go ahead and readjust. So for this next test,
All right. I will take argument from the defense at this time.
Falls short on, especially on probable cause. The officer had very, very little recall of many of the things that we would typically expect to see regarding indicia of impairment. Observations were of marijuana, the presence of marijuana. The officer explicitly said he didn't smell burnt marijuana, just the odor of marijuana. As to the consent for the roadsides, as he testified that he said that it was voluntary, he testified that he said it, that he could refuse, or that it was, I can't remember the phrase that he used, but in the video, the court can see that he didn't state that it was voluntary. He didn't state that the roadsides could be refused. There's a statute that's cited in the motion that speaks to that. So I don't think the consent was voluntary, and I don't think there was probable cause. So I'd ask that those be suppressed as a constitutional matter, as well as any of the fruits of that poisonous tree, including the blood test resulting from the arrest that was appears to be in part based on that, those roadsides. The officer himself acknowledged that these tests really are meant to detect alcohol impairment. He testified very clearly that he's not trained as A-RIDE. He's not trained in drug recognition. He testified that he frankly he doesn't know those things and he's not qualified to. And that's the entire kind of point of my motion is I think that in addition to, like I said, my written motions, I believe that's it. I'm happy to answer any questions that the court has, but I'll leave it at that.
All right. Thank you. At this time, I'll turn it over to the prosecution.
2-MO for the standard field sobriety tests is I'm going to ask you if you are willing to perform roadside maneuvers. The word willing inherently is asking if this is something you're willing to do. Obviously, I don't think anyone would have a question. It would be wonderful if the word voluntary was used. but the word willing here doesn't imply that this is a command by law enforcement, and Mr. Vargas agreed. The standard field sobriety tests in the court's eyes, pursuant to Shrek, are inapplicable to a DUI investigation. This officer testified about indicia of impairment, driving behavior, that there was marijuana in the car, a pipe in the car, smell of marijuana, that he was the driver. That gives a basis for invocation of Colorado Express consent. And candidly, Your Honor, my understanding of Shrek, I understand that courts have discretion to deny defense requests or such hearings on its face until this motions hearing started. I wasn't entirely certain whether we'd be going through a Shrek evaluation, given there is a long history of standard field sobriety tests being admissible for a DUI investigation, regardless of it being alcohol or not alcohol.
All right, thank you. In regards to reasonable suspicion, the court finds that the officer contacted the defendant based on the fact that there was no rear license plate, and then upon contact observed an expired rear license plate in the back window. The court finds that that is enough. In regards to the motion to suppress the roadside maneuvers, the court finds that the roadsides were not voluntary. It was not explained to the defendant that he could refuse. Again, understand that the word voluntary was not used, but at no point in time was it ever explained to them that he didn't have to do these. In regards to whether or not there was probable cause to even ask for the roadside maneuvers in this case, the court finds that there was not enough probable cause to ask for the roadsides in this case. The testimony from the officer in this case is that in June of 2025, he had done less than 10 contacts for driving under the influence, and he was very limited in his knowledge regarding driving under the influence of drugs. The court is unclear whether what he said here at the motions hearing was correct or what was written in his report was correct, but did not indicate to the court that he observed anything wrong in how the defendant turned. He did not observe anything wrong in how the defendant responded. The defendant responded correctly to his lights, and he was fine upon contact. At the time that the officer asked the defendant out of the car, he had expired plates, an odor of marijuana, not burnt marijuana, just marijuana. And the court notes that marijuana is legal in Colorado. That is everything that the court heard. The court does not find that that rises to the level of probable cause to ask the defendant out of the vehicle. The court does not find that there's probable cause nor voluntariness for the roadsides. The issue the court has is the officer can't explain. He indicated he saw 3 clues. The court observed him complete the HGN. It did not look like any HGN this court has ever seen performed in the hundreds of trials that the court has observed. The court never heard anything about the clues for the walk and turn or the one-leg stand, but the only other information that the officer indicated was that he found the defendant to be slow while walking along the sidewalk to the back behind the patrol vehicles to perform. The court observed the body camera and didn't find the defendant to be slow or any of his movements to be slow. He appears to be completely fine. So the court finds that there was no probable cause to invoke express consent and will suppress that as well. Defense has also filed a motion objecting to this officer's testifying in regards to the standard field sobriety tests. The court will grant that in this case. I want to make it clear that it is not this court's practice to suppress officers' observations, but the court is not going to allow this officer to testify to the standard field sobriety tests in this case for the sole purpose of he just doesn't seem to have enough experience to explain to a jury what the standard field sobriety tests are and how the standard field sobriety tests can be used to test for impairment, to determine one's ability to multitask. It was very limited. And the only testimony the court did hear regarding the results was that the officers testified that he found 3 clues on the HGN, which again, I don't know how he came to that conclusion, but I don't think that he has enough basis or knowledge. I just want the parties to be aware that I would not make this finding with an officer who is well-versed in standard field sobriety tests. And it's not my general practice to require an officer to be, I guess, admitted as an expert before allowing some of this testimony. But in this particular case, this officer was just very clear he didn't know what he was talking about, and the court would have concerns about further confusion to the jury. And so the court will grant the defense's motion to suppress standard field sobriety tests. The court will grant the motion to suppress anything after the stopping for the expired plates based on lack of probable cause. And the court will make a finding that everything after basically the defendant stepped out of the vehicle will be suppressed as fruit of the poison.
In a dramatic conclusion, the judge rules that the roadside tests were not voluntary and lacked sufficient legal justification. Finding no probable cause for further investigation, the court suppresses all evidence obtained afterward. The decision deals a major setback to the prosecution's case and reinforces constitutional protections.